You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.
Hello and welcome to the latest Today's Conveyancer podcast. I'm joined this week by Jason Chapman. Jason is an ombudsman at the Legal Ombudsman and is today going to be talking to us about best practice and how you can avoid complaints in the first instance, I hope, Jason, but best manage them as and when they do arise. We've got some sort of questions. We're going to talk about the fact that conveyancing is one of the most complained about areas of law, so we've got plenty to sort of chew over. In the first instance, though, talk to us a little bit about what the role of the ombudsman is, because off air we've been sort of chatting that there's this view of the ombudsman as the enemy, but you want to set the record straight.
Yeah, certainly. I mean, most people will be aware that we've been around now since 2010, so we've been 12 years in the dealing with complaints. Prior to ourselves, it was the Legal Complaints Commission, and we sort of took over as an ombudsman scheme. And by that, what we do is we are an independent organisation. We're not sitting on the side of the consumer or on the side of the firm. We're independent, sat in the middle. We take complaints which have sort of come exhausted through firms' complaints handling procedures. We take the evidence from both sides and the comments, and we come to a determination on what we consider to be fair and reasonable in the circumstances. So what we're looking for is a reasonable service. We're not looking for a perfect service. And then if we find the service has fallen below a level that we consider to be reasonable, what we do is we seek to put the complainant back in the position that they would have been had things gone right. Not always easy to do, obviously, but what we would look to sort of redress any direct financial loss that's been suffered as a result of service failings, for example, and what we would term the traditional sort of compensation. So where there's been hurt feelings, frustration, upset, inconvenience, etc., we sort of award levels of compensation, and they're quite modest. We're not talking about tens of thousands of pounds. It's usually a couple of £100 or less is a sort of our general level of compensatory award. Although we can go higher if things have gone really badly wrong and there's been significant detriment caused to the consumer. But like I say, we're not a consumer champion. I'm not Martin Lewis. I'm there to sort of weigh up evidence on both sides and come to what is a fair determination. And as you say, conveyancing is a major part of that. Just to put it into context, about a third of our total complaints relate to conveyancing matters. Wow,
that's a huge number.
Yeah, and we deal with all areas of law. So you probate, family, immigration, criminal, everything. But by far and away, the most common area of law complained about is conveyancing. And to put it into context, the next most common litigation accounts for about 15% of our total complaints. So more than double complaints coming through to us are conveyancing than anything else. And by the time we get into sort of criminal and PI and families, about 10%. So it's a considerable volume for us.
In terms of sort of real numbers, what does that equate to? There are 1 million housing transactions a year, said quick.
Well, in real numbers, we receive and take forward for investigation about 6,000 complaints a year across all areas of law. So we're looking at about 2,000 conveyancing complaints every year that we sort of take through investigation, and about between 10 and 30% of those will end up with a formal ombudsman's decision. A lot of them will sort of settle along the way, because what we try to do is we try to get the parties to resolve without need for a formal ombudsman's decision. So we'll try and sort of negotiate settlement, mediate settlement between the parties before we go to sort of that formal step, if you like, of producing a report that then, if accepted, is legally binding on the firm.
You talk about redressing the consumer, whether
yes,
it tends to be financially. What's your role then in educating the firm on where they've gone wrong?
The formal ombudsman's decision that's sort of published is a sort of a long document which deals with all sorts of the areas that have been complained about and determines whether the service has been reasonable in each of those. And I think it has to be sort of well explained as to why we've come to the findings that we've come to. So the firms can use that as a sort of a learning tool, if you like, to sort of reflect on what's gone wrong and what happened, and potentially look to sort of correct and improve matters going forward. And we would hope that, you know, that the consequence of that report would be for that sort of learning to happen. But a lot of the complaints are quite straightforward and just sort of relate to sort of a delay or a failure to communicate. And it's just like, well, at the end of the day, it's like, well, you look at what's gone on and you think, well, we didn't pick up the phone to this person for 3 months and things drifted, which the Ombudsman's found to be poor service. So it's really a case of, you know, well, make sure it doesn't happen next time around, or make sure that if you say you're going to pick up the phone to somebody, you actually do it, because if you don't, then they end up upset and complaining about it. So it's just that level. I think, like I say, we do sort of go out to firms, and we do it on a one-to-one basis, and we've also sort of CPD type training where we sort of advise on best practice, which is what I'm talking about today, but more sort of on a more detailed, structured basis. We do have an obligation under the legislation that governs us to sort of go out to the profession and educate and inform them, and hopefully, you know, things like this help with that. But yeah, I mean we see it as a vital part of the service. It's not just determining whether a service complaint was upheld or not. There's that sort of wider sort of giving the public confidence in the legal profession, and also sort of having that sort of giving them the confidence and yeah, just informing and educating and making sure that things can continue to improve.
You suggested that you know, you get some low level complaints, you know, delays, that sort of thing. What typical complaints do you see in conveyancing?
If there was two major areas, I'd say it's delay and poor communications or failure to update. The thing with conveyancing is that we get a lot of people sort of instructing firms who have no expectation, no prior experience of having instructed a conveyancing solicitor to you know, your house purchase is a large purchase. You don't make, well, some people buy and sell houses on a regular basis, but for most people, you might do it once or twice in their lifetime. And for particularly with first-time buyers, they come to firms, they don't really know what to expect or how long anything's going to take, and they've got a level of expectation that perhaps isn't always met. And we find that, you know, the communication is key right at the outset. So firms sort of let their clients know what they can expect, how often they'll pick up the phone to them, how long things are going to take, what their costs are going to be. And it's that level of communication that we find really doesn't happen in a lot of cases. To put it into context, I mean, conveyancing complaints are fairly standard in terms of the numbers that we uphold and don't uphold in our scheme. It's generally about between 48 and 50% of complaints that we receive on conveyancing matters are upheld. So for every 2 complaints, 1 will be upheld and 1 won't. Rough numbers. So what we're not seeing is lots and lots and lots of poor service where we're upholding virtually everything. It's sort of about 1 in 2. But where we do uphold the complaints, we're finding a lot of stuff it could have been avoided just by, you know, setting expectations and communication and updates and letting people know how things are going to work and what they can expect. And so because people aren't told that, they don't know, and all they can see is they want to buy a house and they made an offer and it's been accepted and they want to be in and, you know, cooking their first breakfast and so on and in that house and enjoying the garden and getting out the pokey little flat that they're in at the moment. But they don't understand how long that's going to take, and the fact that things can drift, and it's not necessarily the fault of the firm that they do. But firms aren't particularly good in some cases. Some are very good at it, but some of them aren't good at sort of setting expectations and letting people know how long things are going to take and what's going to happen. So that does then generate complaints, which are, like I say, completely avoidable.
It's that culture of immediacy almost, isn't it? You know, we can get our Amazon order the next day. We can order an Uber from our phone, but it takes us a little bit longer to move house, and setting those expectations at the outset.
Exactly, and we see that across all areas of law, but particularly with conveyancing, where people are buying houses.
What about the SDLT extension? Is it too soon to say there's a spike, or have you seen any rise in complaints?
this is huge for us, and it's coming through. We're starting to come through now. When I say that 30% of all our complaints relate to conveyancing matters, what we're finding at the moment is a quarter of all our complaints relate to SDLT. And so 1 in 4 complaints that's come into our organisation, which, like I say, across all areas, is relating to SDLT. It's huge for us, and what we're finding as well is it's having knock-on effects into other areas of law. So firms were dealing with SDLT issues and parking other issues, so there's been delays on those matters. And then when we're asking firms about it, they say, oh well, we had a rush on of completions to complete before the SDLT window closed, so we had to park stuff like that. So it's been huge for us. It really has. I mean, what we've seen with the conveyancing industry, and we have had a huge spike in complaints generally recently with them, but we've had a perfect storm. We've had pandemic issue. We've had pandemic, and we've had the pandemic issues. We've had firms who have furloughed staff. We've had firms that haven't been able to access paper files in their office in some areas because of pandemic restrictions. Haven't been able to deal with complaints because fee earning staff haven't been around because, like I say, they've been furloughed. So complaints haven't been progressed. So they're coming to us with people saying, oh, the firm never responded to my complaint, and we're finding that they haven't for those reasons. But that's caused a problem. And then as soon as the pandemic restrictions eased, then we were into a boom on the housing market and the SDLT window, and lots and lots of complaints are being generated by people saying that they missed the deadline and they've had to pay SDLT. And if you do, then your natural reaction is, oh well, it's the firm's fault, and I expect them to reimburse me for that loss. And so we're having to deal with these sorts of issues. But of course, what we've found, unfortunately, and it's completely understandable, because firms have not been able to earn fees during the pandemic because the market's been flat and the restrictions have been on. And as soon as they come out of it and they get the chance to take on a lot of work, they do that. And that's understandable, because you want to sort of get back on an even keel with your business. But firms have been taking on too much. It's very clear to us that certain firms have been taking on far too many clients, and they're not being able to service them properly. And whereas it's rare that we are determining that SDLT costs should be reimbursed because the window's been missed, it's rarely the fault of the firm. What we are finding is that maybe the expectations haven't been managed properly. But where we see good firms have done well is where they've said, look, we can't guarantee this. We can't guarantee that your purchase will complete before the window, but we'll do everything we can to try and make it happen. And then when it doesn't, it's not. But we've seen that it's a combination of all these things. But yeah, at the moment, SDLT is huge for us, and we see it being that way for a while. Prior to pandemic, we had a lot of issues with doubling ground rent clauses. Those have sort of gone away a bit now. We're still seeing the odd one or two. Ground rent as a whole is an issue, and it always has been, to be fair. Failure to advise them, then people move in and find out they've got a liability that they perhaps weren't told about. But again, you need to make it clear to your client, because a lot of the time it's all new, and you've been given lots of information as a first-time buyer, for example, and it's what you take on, and firms have got to be clear about potential liabilities. I mean, with the SDLT stuff as well. And we're seeing this with not just with SDLT, but also with multiple dwelling relief and help to buy. Firms aren't really providing advice about it, but then when they're getting a complaint about that, are saying, look, to be fair, we're not tax advisors. We don't provide tax advice, and we consider this be a tax issue. Now, yeah, we can understand why that would be the case, but SDLT, help to buy, they're not sort of tax issues to the extent that you'd need to be a qualified accountant to advise them, and a reasonably competent conveyancer should be able to know whether you're entitled to multiple dwelling relief or help to buy, and provide advice on what you should do to go about claiming it. And also in terms of the SDLT, well, it was fairly well known about the extensions, the windows, and what the levels of were, and firms should have provided advice on that, and a lot of them did. It's not. We don't consider it to be something that you'd have to instruct an accountant to go and give you that level of advice. Any reasonable Conveyancers should be able to at least, giving you an overview of what you could expect and what the process was. But we're finding that hasn't happened.
Are there cases where you've actually reimbursed the value of the stamp duty lost?
We've done it once. So far, we've done it once. We've had a lot of complaints, and that was the only one, because the firm had the chance to complete on the day before the window, and they didn't bother to sort of follow up with the lender as to whether the funds were in, and it just went over. So we could reasonably determine that had the firm done what they should have done, then they would have got inside the window. But as it was, they delayed over that, and so the loss, we found it fair to direct the loss against them. The typical amount that we're finding that people are claiming for this is between about £5,000 and £10,000 on average, but we've obviously had some much higher depending on the value of the property.
You obviously step in at the point in time where the law firm's complaints procedure has been exhausted.
Yeah.
And you've talked about the fact that you have a role to kind of educate. What do you advise firms do when it comes to complaints? How should they be dealing with them, and how can they deal with them better?
Well, I mean, the first thing I'd say about this is that you're never going to completely avoid complaints. We live in a fairly litigious society. People are well versed in how to make complaints, and they're well versed in the concept of compensation and loss. So it's very difficult for firms to consistently avoid complaints, especially if you're sort of a high volume sort of conveyancing firm who's dealing with a lot of completions on a monthly basis. The chances are you are going to generate complaints, and it doesn't necessarily mean that you've done a poor job. It's just the market and the volume of work that you're working through mean that some people will come out of that process unhappy. Like I say, it doesn't mean you've done anything wrong. What we always say is that the first step is to recognise the complaint, because we get people coming to us saying that they've complained to a firm, and when we contact the firm are saying, well, we've received no complaint, but then we receive the correspondence from the client, and it's clear that a complaint has been made. But it's not always easy. I mean, what we say is that if a complaint letter comes in and it's got formal complaint in big red letters at the top of it, then it's pretty clear what the intention of that letter is. Equally, people pick up the phone and make inquiries about, for example, their bill. Is this right? And that's not necessarily a complaint, that's an inquiry. So you've got that sort of, but that's sort of the two extremes. But in the middle, you've got a bit of grey, and sometimes complainants think they're making complaints. The firms don't pick it up. Sometimes they should have done. Sometimes, we look at it and go, no, we don't think that's a complaint. You need to complain, because you have to give the firm the opportunity to respond to the complaint and provide potential and redress if they consider it appropriate to do so. But the advice that we give at the very outset is, if you've got any doubts about whether it's a complaint or not, treat it as a complaint, or at least ask the client what their intention is. Are you complaining about us? Do you want us to provide you with the complaints handling procedure, and do you want to sort of progress it that way, or are you just asking questions? But what we don't want to do is get to a stage where we're stepping in and saying we think there has been a complaint made, but the firm haven't responded to it because they didn't think it was a complaint, and then the 8 weeks that we allow has passed. So then we pick up the complaint based on the fact that there's been no response to it. So which causes the firm a problem, because that means that our case fee will always apply, which is £400 per case. So that's the first instance, is learn how to recognise the complaint, which again isn't always easy. But like I say, if you err on the side of caution, at least ask the client. These
would typically come into the fee earner that was dealing with the matter in the first instance, wouldn't it?
It does, yeah, because that's the logical thing, isn't it? And this is my next point, really, in terms of a complaints handling process and what is appropriate. And firms are required to have one, but it's difficult because sometimes firms won't have had a complaint for years on end, and then they get one and they don't really know what to do with it. So my next advice will be to make sure that your complaints handling process is in a place that you want it to be, in terms of how you're dealing with complaints, and make sure that it's up to date. We've seen complaints handling procedures that are sort of incredibly convoluted and really designed to prevent people from making complaints, and we don't feel that's appropriate. We had one where there was an 8-stage process where you complained to the fee earner, then that fee earner's supervisor, and then the managing partner, and then the managing partner would would insist on a meeting, and then after the meeting, if you still disagree, then they'd refer it to a local barrister to decide whether the complaint was upheld or not. And if you weren't happy with the barrister's advice, then they'd pass it to another chambers for another barrister. And it was only after all these steps they would determine that the complaints handling procedure had been exhausted, and they said at that stage you can go to the legal ombudsman and have them look at it. But it was very much a sort of a process designed to stop or frustrate complaints and prevent. Because the lady that I dealt with on that particular one, it was a sale of an estate property. Where I think her mother had died, and the property was in London, but the lady was in Wolverhampton, so 150 miles away. And by the time it got to the meeting, she said, "Well, are you going to reimburse me my costs? Because I've got to drive all the way from Wolverhampton to London and back." And the firm were like, "No, we're not going to do that." And then she brought the matter to us, and we had a look at it and go, well, we don't feel it's reasonable for you to incur that cost. And because the overall process by that stage had taken the 8 weeks, we took it on and determined it. But the firm are obviously unhappy because from their perspective, the complaints procedure hadn't been exhausted. But we determined we would always look at what was reasonable. So in what we'd usually say is, yeah, by all means have a process where you complain to the fee earner, because that's sensible and fair, because they're the person that's dealt with the matter, so they've got all the ins and outs and they know the facts of it, and they can look at what's been complained about and respond to it. But then have an escalation process that's perhaps then to a managing partner to have a look at the overall file and determine whether what's gone on is reasonable or not. And then at that stage, once that's happened, if they don't want to appear, just bring it to the legal ombudsman at that point. We see a lot of different sort of levels of complexity in complaints handling procedures, but that's what we would say. Just make sure that it's a easy process for the complainant to navigate, and also it's very clear to them what they have to do to raise a complaint, who they have to raise it to, and what the process is.
There's a very natural part of an organisation to defend itself against a complaint, though, isn't there?
Yes, absolutely, and we see this in the complaints responses that we receive, and this is the next sort of point, really, is in terms of the responses, and we've seen sort of very defensive responses, and I understand that, because just like complainants, for feeling solicitors and partners getting emotionally invested in the complaint, and nobody likes criticism, but we would also say try and remain neutral and professional in tone, and fairly and sort of just deal with the matter. Don't get involved in a sort of the emotional side of it. But we have seen that we've seen it a lot with sort of complaints responses down the years, where some of them are quite passive aggressive or just outright aggressive on occasions, and it's just not appropriate. But the other thing that we see a lot in complaints responses is that solicitors will sort of resort to legalese, and sometimes there's an attempt to sort of intimidate people. We would say just keep it jargon free, keep it plain English, keep it simple, so people understand it. Because you might find out that they accept the response, but if it's all sort of references to caveat emptor and res ipsa loquitur, then people can think, oh no, I don't accept this, and then bring the matter to us. So we would always say, keep it simple, straightforward, address the issues, and before you, obviously, as part of the investigation into the complaint, make sure what those issues are. Because what we do is, when we get a complaint, is we go through what we call a scoping exercise, where we will contact the person who's brought the complaint and say, this is what we think you're complaining about. Is that right? And then if they say, oh no, well, I was also upset about the costs, and it's in the complaint letter, and then you can sort of include it in. But we also find that firms sort of misinterpret complaints sometimes and deal with what they think is the issue, whereas actually it's not. But if you're not sure and you go receive a complaint and you think, I'm not really sure what I know it's a complaint, but I'm not sure what they're talking about, again, pick up the phone and say, are you upset with the cost, or is it just the fact that it's a bit of delay, or what are your issues? And then you can sort of address them directly, rather than having a bit of a guess about, oh well, I've had a bit of a sort of a rant when we see these a lot, sort of stream of consciousness rant, you're terrible, etc., and thinking, oh well, I think she's probably upset about the cost, so I'm going to address that. But actually no, she's upset because you didn't contact her for 3 weeks and she was expecting a call. So it's that kind of thing, really. Just make sure that you're scoping out the complaint and boxing it off, and then dealing with it in an appropriate way.
We've covered a lot of ground there. That's been really interesting. Thank you. Do you have any feel for how it impacts professional
No,
indemnity?
no, I really don't. I know that there's a requirement to disclose any sort of outstanding complaints that are with us. I don't have a feel for it. I mean, in a sense, in a way, it's not really relevant to us because we are a scheme that's set up to deal with complaints by consumers about service providers. So we're not sort of it's not really something that we consider because we're there just to determine the complaint. Sometimes there's no fault of the firm, so we just find against the for the firm. Sometimes there is, and we find against the firm. So it's not something that we're really concerned about.
When does the case fee kick in? Because you must get spurious claims.
Yeah, the case fee kicks in at the point where the case is allocated, so it's applied until it's disapplied rather than being applied at the end. So the point where we accept a case for investigation, the case fee is applicable, and it's only disapplied in certain circumstances at the end where the complaint's handling has been reasonable and the complaint has been determined in favour of the firm. So if a firm say, yeah, we know things have gone wrong and we're going to, we offer you £200 in compensation as a goodwill gesture, and we go through and say, yeah, we agree things have gone wrong, but that offer was reasonable, then that's been found in favour of the firm because we've said actually what the firm did was right. So at that point, we would disapply the case fee and there would be nothing to pay. If the complaints handling has been reasonable and all the signposting has been done and everything else, so the person knows to come to us and the appropriate time limits are given, then we wouldn't apply the fee. But it's applied at the front end rather than being applied at the back end, if that makes sense.
And I think that was a frustration when it was introduced, wasn't it?
I mean, we're looking to potentially change it further down the line, but it needs Lord Chancellor's approval to do that, and that's Dominic Raab, and we think we're important sat in this office, but we're not important to Dominic Raab. Completely understandably, we are not even on his radar. But to change the case fee, we would have to go through that process. So that is something we might want to do further down the line, and we would sort of do it through the Ministry of Justice, I guess, who we are sort of a part of. But we don't have a lot of discretion with case fee, unfortunately. Like I say, there's times when you think, well, really, it would be the right thing to do to apply it, but because the way that the scheme rules our scheme rules that govern our scheme are drafted, we don't have any wiggle room with it really, so we can't sort of disapply it. Use any sort of discretion to say in the circumstances, don't worry about this. We don't have that, and that's a considerable frustration to firms. It always has been. When we started off, we had 2 free case fees so you would only attract a case fee on your third complaint. But we chose to move away from that in about 2013, and since then we've just charged for everything. But like I say, if I stand up in front of a room of solicitors, case fee will always come up, and the issue of negligence. And they always want to talk about where do you draw the line in terms of your investigation with where's the allegations of negligence, because you're not a court. You're not there to determine legal things that turn on legal matters. We're just here to look at service, and there's an overlap. You can't be negligent without having provided a poor service, so we could always look at the service aspects of it. But yeah, case fee and negligence are the 2 things that always come up, and also dealing with challenging complainants. We get a lot of sort of stuff on that because it's at the end of the day, it was conveyancing firms. They're just there to buy and sell, do the legal bits of buying and selling properties. They're not geared up to having people screaming and shouting down the phone at them and threatening them and all the rest of it. But we see that because people get very upset and emotional about things,
which sadly is what happened throughout the SDLT sort of extension, wasn't it?
Absolutely.
You saw a huge amount of public frustration placed on the shoulders of the conveyancers. It's been a really reassuring discussion, I think, Jason, it's fair to say. Good. Because the view of the Ombudsman as the enemy is wrong. And I think it's fair to say that you've sort of set the record straight on that front. But some really good pointers there for firms to take away and have a think about in their own organisation. That's it, as much as we've got time for, albeit we could probably talk about this for the rest of the week, never mind the rest of the day. Thank you so much for joining. It's been an absolute delight to chat with you. And thank you very much indeed to everybody for listening. The Today's Conveyancer podcast is available on your preferred podcast provider, and it's also available on the Today's Conveyancer website. Thank you again to you, Jason. Thank you for listening.
Thank you.
And speak soon.
You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.